if you're between the ages of 50 and 54, you have not worked at all in the last 5 years, depends either from the filing date or date last insured or the date of the hearing, just depends. Okay. And you can have a doctor and you can establish evidence that you cannot sit for, that you're limited to sitting for 6 hours, standing for 2, and you can't lift more than 10 pounds under the current regulations, you're likely to win your case.
Yes.
Yeah. Now, I have a question for you.
Yeah.
What if they do have past work? What if they have worked in the last 5 years? What are things that you're looking for to make that case a little easier? Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode. Well, good morning, Your Honor.
Good morning, Pete. How are you?
Well, I'm great. Thank you for asking. As always, it's a pleasure to see you. I know how busy you are, so I'm always grateful for any time that you and I get to catch up a little bit and to talk about Social Security rules. And then
Our favorite topic.
Yeah. I think it'll be an interesting topic today. And just for those listeners who don't know you, your name is Dan Hyatt, and I'll link. We did a great bio video, and I'll link the video to that. But your name is Dan Hyatt. You're a former Social Security administrative law judge who decided these Social Security disability cases for, I would guess, about 20 plus years. And so you have a unique insight on Social Security disability cases and disability matters. And besides that, you've done a ton of other service, including active military in the Navy, and have served our country and just really served our country in a lot of great ways. So, and I'm always so proud of you and that kind of example you have set. So,
well, thank you, Pete. I appreciate that.
It's amazing.
It's been an interesting life for sure.
Yeah. No, there's a lot of cool stuff that, and I don't want to deep dive into it too much, but there's a lot of cool stuff that even movies that have said, man, this has been an interesting life, and let's make a movie about some of it. So, but we're not here to talk about the movies. Instead, we're going to talk about a much more interesting topic to us, I guess, and maybe a few of our listeners. We did a podcast about kind of the top 10 most difficult cases to win.
Right.
And that kind of, and I'll link to some of those videos in our description below. But today, and one of the things we've been wanting to talk about is kind of the top 10 more easier cases to win. Not necessarily meaning it's an automatic win, but definitely a lot more easier. And in some cases, it could be an automatic win. And I wanted to kind of walk through that list that you and I created and hear your insights on, kind of generally on each list. Why is it a little bit easier to win? And maybe talk about, what evidence you might need or how to define the words we're using for an easier case to win. And that way, if people do kind of check the criteria for those things, they know that they have a very, very strong chance of winning. And kind of like in the videos we talked about the top 10 most difficult cases to win, we take those cases on, and it doesn't mean you can't win, right? And kind of in the adverse here, it just kind of a disclaimer, even though we say these are the top 10 sort of easiest or easier cases to win, it doesn't mean we're guaranteeing someone's going to win
Right.
in their case, And
Right.
as
Yeah.
you and I both know, so much of it comes down to the decision maker.
It does. Yeah.
If the decision maker is inclined to deny the vast majority of people in front of them, I don't know what, even if you're on that top 10 list of criteria, you may lose anyway,
Well, and then, of course, you've always got the right to appeal. There are a couple of judges that come to mind for both of us who have been notorious for paying only maybe 10% of the cases, people that appear in front of them. And we won a number of appeals of decisions by those judges. So as long as you have a good record, it's not over till it's over.
Right. And I agree. Just so many people get discouraged, if they go in front of that type of judge and are denied. Just remember, if you are denied, you can appeal.
Right.
So let's talk about it. And so I'll go ahead and kind of refresh your memory on the top 10 list we put together.
Sure.
And then maybe you can deep dive into it a little bit. So number 1 on the list is, we said people or claimants who are over 50 who have both mental and physical impairments.
Right.
And maybe if you could talk a little bit about over 50, why that matters, and then what you mean by mental and physical impairments.
Yeah, well, okay. So I think we've mentioned in previous podcasts that there are statutes that need to be followed by an administrative law judge. And one of those is called the Medical Vocational Guidelines, or the GRID rules. And those provide kind of an escalating level of presumptive disability based on age and ability to lift and carry a certain amount of weight. So below the age of 50, those GRID rules rarely apply, but over 50, they're referred to frequently. Usually, I would say, if we have a physical and mental impairment, it would tend to indicate a more favorable presumption. So if you're over 50, between age 50 and 55, you have no past relevant work, and you can only lift 10 pounds, or you can only stand or walk 2 out of 8 hours. That's gonna probably result in a favorable decision based on the medical vocational guidelines.
Right.
If you're over 55, and you can only do light work and you have no past work. Now, light work means you can lift 10 pounds frequently, 20 pounds occasionally, and you have to be able to stand or walk 6 out of 8 hours. So, but if you have no past relevant work, and we'll talk about that a little bit more later because the rules have recently changed about that, but that would indicate a much better likelihood. And then, of course, over 60, it's even easier to establish disability.
So I just want to recap. Generally, the big picture here is that the rules within Social Security, and I'm going to use layman's terms first, and then I'm going to kind of ask you a few more questions. Generally, the rule is the older you get, and they mark this criteria by 50 to 54, 55 to 59, and then 60 plus up until your full retirement age, Social Security retirement age.
Right.
The laws change in such a way that it becomes a little bit easier to win at each phase.
Right. And not only that, but you mentioned both exertional and non-exertional. Non-exertional is generally going to be mental impairment, depression, anxiety disorder, that sort of thing. Exertional is going to be the ability to lift, carry, walk. So if you have a physical problem and an emotional problem, let's say that you're depressed and your memory is poor, or you have anxiety and you find it very difficult to leave your home, those are going to tend toward a favorable decision.
Yeah. So one thing I want to make clear for the audience, and just kind of a little bit of a deeper dive. When you're under the age of 50, so between the ages of 18 and 49, you're considered a younger individual.
Right.
And as a younger individual, you have to prove you can't do your past relevant work,
right,
which is currently defined as all the work you've done in the last 5 years. And you also have to prove there's no job that exists in significant numbers in America that you can do.
Right. And let me throw in a caveat, Peter. They're changing the rules. In the last 5 years, they look at your work in the last 5 years. If you've got an expired insurance policy, when you stop working, your insurance will cover you for about 5 years after you stop working. If it's more than 5 years since you worked, they're going to go the 5 years before your insurance lapsed.
Right.
Same thing with an SSI application, supplemental security income. They're going to go the 5 years before you actually filed for SSI. So generally, though, 5 years, if you haven't worked for 5 years and you're fully insured, that's a good situation. That's a really good situation to be in.
Can I ask a question that I genuinely, because the law just updated, is it 5 years from when you filed? Because in PRW used to be defined as 15 years from the date of whenever they're doing the hearing or the date of the decision. They look 15 years back, not from the
being made. Yeah.
Is it 5 years from the filing date now? Did they change that?
Only for SSI. Because,
only for SSI.
Yeah. For DIB, disability insurance benefits, the last 5 years from date of hearing, unless you have an expired insurance date. Then they'll go 5 years before that.
Okay. So that law just changed like a month ago, I think, or maybe it's been a couple months ago. But so, which is good to know, because it's when we talk about insurance, we're talking about Social Security disability insurance benefits, and what's commonly I don't know about commonly referred to, but what's referred to within the Social Security Administration circles and attorneys is known as the date last insured. And we're not talking about medical insurance. We're not talking about Medicaid. Just for listeners who may not know, I think, so often they think, oh, I have insurance. And the most popular insurance people talk about is health insurance. So this is this Social Security disability insurance benefits program. The other thing I wanted to...
When you work, you pay FICA taxes.
Right. You pay FICA
and that buys you that insurance.
Yeah, exactly.
Okay.
And typically, you have to pay for 20 out of 40 quarters to generate the insurance.
Correct.
Unless you're under the age of 30, then it's kind of...
Or blindness.
Yeah.
Blindness, you only need 6 quarters. Yeah.
Yeah. So there's some exceptions to that, but generally, it's 20 out of 40.
Right.
Which is 5 years out of 10. Mm-hmm. So number one was, we talked about over the age of 50 with severe mental and or physical impairments. Actually, number 2 on our list, which you've sort of addressed, was over 50 with no past relevant work, and then being limited to basically what we call sedentary level work.
Correct.
You have to physically prove, or you have to prove that you're limited to sedentary work.
Right.
And you said earlier that sedentary work is defined as the most you could sit in a day is 6 hours out of an 8, or you could sit up to 6 hours out of an 8-hour day, and you could lift up to 10 pounds.
Correct.
And if you're between the ages of 50 and 54, you have not worked at all in the last 5 years, depends either from the filing date or date last insured or the date of the hearing, just depends. Okay. And you can have a doctor and you can establish evidence that you cannot sit for, that you're limited to sitting for 6 hours, standing for 2, and you can't lift more than 10 pounds. Under the current regulations, you're likely to win your case.
Yes.
Yeah. Now, I have a question for you.
Yeah.
What if they do have past work? What if they have worked in the last 5 years? What are things that you're looking for to make that case a little easier?
Well, you're going to look at what type of work it was that they were doing, why they left that job, and if it requires more than sedentary exertion, it's not going to count at age 50, unless, well, there are exceptions to every rule, but that's generally going to be the case. So you're going to look for ways to knock that past work out. Let's say a person is, let's just take a real simple job. Their person is a telephone solicitor, and so they're doing telephone work all day. That's generally going to be sedentary work. Well, if the person that you're representing is having memory problems, or if they're having problems with their hands or fingers where they can't really keyboard, because that goes hand in hand with telephone work, you try to find ways to preclude that past work based on their medical impairments. And that could be either mental or physical.
Right.
Yeah.
So it's important for our audience to know it's 2 phases. Phase one, you got to prove you can't do the work you used to do.
Correct.
Right. So you got to get past that hurdle. That's hurdle 1. I mean, it's actually the second hurdle, but you got to get past that hurdle, proving you can't do the work you used to. And then you have to get past the hurdle of, and we use transferability of skills, or are there any other work that you can do? So it's 2 different hurdles. So
that's correct.
What you're saying is if your past work is sedentary generally, and you're saying, you use the telephone solicitor job, but there's other sedentary work, small products assembly, things that kind of get thrown in our face in a hearing, that if you're limited to sedentary, you may not pass that first hurdle that you can do your past work. Right. However, you got to eliminate that before we can even get to the second job. If you can eliminate your past relevant work and it is sedentary work, it's likely you will have a better chance of proving, well, if you can't do telephone soliciting or small products assembly or whatever your past relevant work was, then it's likely you will eliminate other sedentary work as well.
Well, and interestingly, the burden of proof shifts at that last step. In other words, it's incumbent upon the administrative law judge to establish with a vocational expert's testimony that you're fully capable of doing some other work. And this applies whether you're 50 years or old or 22.
Right.
Along the way, even for younger people, the burden of proof is on the government to prove that you can do other work if you can't do your past work.
Right. Well, this is where it gets a little bit complicated because, and I think we, and you and I are going to do some podcasts just talking about kind of the field of Social Security disability lawyers, but this is where it really pays off, in my opinion. And I want to ask you too, like in your opinion, as a former judge, to have a well-trained Social Security lawyer in a hearing with you, because who's answering the questions about past relevant work, about transferability of skills, is a vocation.